right, guys. My name is Anthony Bandiero, attorney and senior legal instructor for Blue to Gold Law Enforcement Training, bringing another Search and Seizure show. We just finished drones, LPRs, and poll cameras. We had hundreds and hundreds of people on the webinar. It was a lot of fun. Now I'm going to answer some questions. So, yep, and cool. So, if Michael, if you know anybody, please let us know. Because you're right, we do need a lot of. So just so you guys know, they're watching us on YouTube and so forth. We still have several hundred people on this webinar who are going to hopefully hear my answers to questions. Also, here's how this works. If you guys have a question, you cannot turn on your camera. Okay, you're only going to see me and my beautiful face. However, I want to hear you. Does anybody here have a question for us? A question for me? Would you like to ask a question? And just all we'll do, I'll do is I'll turn on your mic. You know, you have to accept okay, and you have to give me permission. Okay, Anthony Smith. Let's answer the question. So what I want to do is I'm going to answer a live question. And Rick, do me a favor. We got to remind me to turn off that reaction thing. I absolutely hate it. Thank you. I keep forgetting to turn it off. I just absolutely hate it. Okay, Anthony, you should have your mic. Be able to turn it on.
Yeah, I hit unmute. Can you hear me?
Okay, cool. Hey, what's up, buddy?
Not much. Just something I caught at the tail end of the webinar. You said something about, you were talking about quadplexes, which I assumed you meant like a 4-unit apartment building, like where there's 4 different apartments. You said briefly that there's no curtilage in a quadplex.
No, negative. And go ahead.
Well, it's okay. Oh, go ahead.
Well, I didn't mean to cut you off, but but the reason why is because curtilage requires exclusivity, right? It's exclusive to that person. Curtilage is treated like the home itself, right? That's a case called Hardiness. How can you say that a backyard that's shared with 3 other families, right, is like your home? It's like your kitchen. It's not. That's why it cannot be curtilage. However, depending on the state and their view of the Fourth Amendment and so forth, it still can be protected by the Fourth Amendment, but not at that curtilage level. It's going to be under just a standard, vanilla, good old-fashioned, reasonable expectation of privacy test.
Now, would that apply to, in Pennsylvania, we have a lot of 2 units as well, like side-by-sides. Would you see that the same way, that it's 2 rented units and technically it's open to either one?
So you're saying that you have a scenario where you have a duplex and they share the backyard, like they can be on the left side, the right side. It's both of their backyard.
Well, I'll ask you both ways. Yes, and then what if no? What if there happens to be a fence going down even if it's just a little, like a chain link fence or something?
Correct.
So what if it's open, and what if it's not open?
Okay, good. I love it. So if it's open, look, it's not. I should say this. In my experience, because we have a lot of duplexes in Las Vegas as well, right? In my experience, there is this agreement that you don't mow another man's lawn, right? You don't go into the left side if you're on the right side. Even if there's no fence, there might be some telltale signs about where the boundary marker is. But regardless, even if it's a space that looks open, it probably, like, the left side belongs to the left person and so forth. However, if it is designed to really be a community space where there's like a barbecue pit in the middle and either one can use it, they're, based on social, conduct and agreement, it's both of their spaces. It's not curtilage. However, we can also agree though, that when you go from 8-plex to a 4-plex to a duplex, right? That you're getting more and more. You're building more and more reasonable expectation of privacy. We can agree on that.
Yes.
A duplex just feels more private than a quadplex, and go on. So if I had a cop, let's say that we, especially Pennsylvania, Pennsylvania is obviously it's an okay state for the search and seizure, but you have to be careful there, right? So,
right.
But let's say we had an officer say, "Oh man, I think he's dealing drugs out of his duplex," and the word on the street is he hides it under this bush in the backyard, and the backyard is kind of like an open space where either one can access it. I would not be jumping that fence. I would not be saying to myself, it's not curtilage, so it must be open field. No, I do not think it's open field. I think it's an area of a reasonable expectation of privacy. So therefore, I would be getting exigency, consent, or a warrant. And the consent can come from the other guy, by the way, right? Because if it is a shared area, then the other neighbor can also access it, and therefore he can give you consent. But to answer your question, it's still not curtilage. No.
Now, do you think it would change a little bit? We'll stay with the duplex part because, like I said, that's a little more restrictive. What if the property owner occupied one of those units? Could they argue that I only allow myself and my tenant onto this property? Like, would that change the discussion if the property owner was one of the occupants of one of the units?
And so you want, but what's the question is, you want to hop at the fence and not get anybody's permission, or do you want to get the landlord's permission? Is that what you're kind of like?
Well, if it's if we're saying there's no curtilage and we could go onto it, but what if one of the owners, one of the occupants is the owner? Would he have even with the tenant's property, would he have an expectation of, hey, this whole thing is my property, as if it was one big unit or one big house?
Right. Well, I want to be careful though. I really do believe, I think hopefully I made this clear. I do believe that if you are dealing with a duplex and they
Mhm.
do have a shared backyard, like it's socially acceptable for them to just use this backyard, throw a baseball or football around, barbecue back there, and it's that shared space, but it's just down to these two people. It's not curtilage, but
Okay.
it is an area of expectation of privacy, and we should not look at it as an open field. It's especially when it has a fence around it and so forth, right? So it's not going to be like I would not look at it as a common area of an apartment complex. A lot of apartment complexes have what shared barbecues, right? Little shade structures and swings. Those are not curtilage because everybody just shares it, right? But
Yeah.
this
Big parking
duplex,
areas.
but if you do have, and look, I think, look, in my experience, most duplexes, their backyard is delineated. It is segregated. You stay on your side of the duplex, right? And that would be curtilage. I think we can agree on that.
Right.
But if it's some odd, I think an exception where it is a shared space, it can't be curtilage because it's not like your kitchen, right? It's not shared. Your kitchen is not shared, and right, so it's not curtilage. However, it's still there's still a privacy interest there, and cops should be very careful going back there without any permission. Going back to the landlord, if it is a space for the tenant where it is exclusive to the tenant, and the cop is like, yeah, that's pretty much their space, they cannot get the landlord's permission to be back there, because obviously the landlord does not have common authority over their tenants' private areas. So you still have to be careful
Gotcha.
unless it's shared. Unless it's shared. If it's shared, then you can get one person's permission. Cool.
Gotcha. Thank you.
I hope
Yep.
that
Thank you.
helps. Okay, you're welcome.
Yep.
Okay. Let me, Anthony, I appreciate that. Okay, cool. So I turn off your mic, Anthony, so you're good to go. Who has a question? But as I tee you up, let me just, Mike Long, let me just, because I do have some other questions to kind of get through. If you don't mind, I'm going to go back and forth. Mike, are you on deck? You ready to, right? You're going to be on deck in a second here, okay? Okay. So this question comes from an officer in Ohio, okay? And he says, bring up the, okay. He says, hey, look, if I stop, Ohio now has constitutional carry, they can carry firearms in their vehicle and so forth. But basically his question was, all right, I stop a vehicle and the guy has a rifle in his, like, in his back seat, maybe his passenger seat. I know that sounds kind of weird to a lot of you guys, but sometimes I roll around like that too because I'm worried about the Canadians invading. So he has this rifle and there's a magazine in the rifle. The cop says, "Hey, is that gun loaded?" And he's not answering any questions. Now, the question for the cop is saying, "Hey, can I search that vehicle? Can I run that serial number off that rifle?" The first question is it illegal in Ohio to have a loaded rifle in the vehicle? And I believe the answer is yes. I'm not positive on this, but I'm pretty sure that from my research, the answer is even with constitutional carry, the constitutional carry does not apply to rifles. It applies to pistols, right? So Ohio Revised Code 2923.16 says it is generally illegal to transport a loaded, hold on, A loaded rifle. I think I have the right law here, but it's a loaded rifle unless it's in a storage container. You're in law enforcement. You're exempt by law enforcement. You do have yeah, it says that Ohio law does not extend concealed carry privileges to carrying loaded rifles or shotguns. That generally applies to handguns. There is a hunting exception if you're lawfully engaged in hunting. I think you got to be careful hunting from vehicles. But look, here's my point. My point is that if it is illegal to have a loaded rifle in the vehicle under these facts, and then you see a rifle with a magazine inserted, does that give you consent? I'm sorry, does that give you probable cause that they're violating the law? Yes or no? And the answer is yes, right? In other words, if you see a rifle with the magazine inserted, is there a fair probability that rifle is loaded? Yes or no? You don't think it's probable cause? Guys, you don't think having an AR-15 with a magazine in there is at least not certainty? I mean, do you think that this thing is loaded? Yes or no? Do you think there's a fair probability that this thing is loaded? I mean, even you don't know if there's something in the chamber, but you don't think there's a fair probability this is loaded right now? So the answer, of course, is yes. Probable cause is a common sense determination of the facts before you, right? And it's only a fair probability. Is it a fair probability that there's actually a bullet in that chamber? Why are the gun is right there, open, accessible. Why do you think they have a gun right there? Do you think it's maybe for self-defense or offensive purposes? The answer is yes. So, I think you have probable cause. Therefore, if you have probable cause that they're violating a law, and again, you have to make the determination, not me, that they're violating the law, then that gives you probable cause to search that vehicle and gather evidence. That means that, yes, you could seize that firearm and check it to see if it's loaded. You can search it, and if you have access to the serial number, you can run it. That's another running serial numbers. I have a video on that. Generally speaking, if first of all, this is part of the investigation, so we have no problem. But running serial numbers as part of a routine traffic stop when the person is lawfully carrying, I have a problem with that. If you want to know more about that, let me know. Mike, I'm gonna put you on deck. It's Mike. Sorry, Mike Long. Okay, there we go. All right, Mike. Serial number may not be a search, Brooks. We can talk about that if you want. It may or may not be a search, depending on the circumstances. All right, Mike, can you hear me?
Yes.
Hey, how you doing, buddy? Where are you from, by the way?
Kansas.
Nice. What you got?
It was a pole cam question. Installing a pole camera in a backyard, where I've stood in the backyard and can look into suspect's backyard. We then install a pole camera, to allow us to then conduct surveillance away from the house. The homeowners give consent. And then does it make a difference if the camera is at ground level as opposed to an elevated position on the house?
All right, so let me just make sure I got your facts right. So are you saying that so you put the camera on a neighbor's property?
Yes.
And okay, and so they can see like from the neighbor's law, like where the neighbor would lawfully be? They can
Yes,
see
like
inside
standing on their back
backyard?
patio.
Yeah. So if the neighbor was standing on their back patio, they can see inside their neighbor's backyard,
Yes.
and your camera sees the same thing.
Yes.
Okay. So the answer is that I believe that is not a search under the Fourth Amendment, right? Right to be, right to see. If you have a right to be, like, again, being on a pole is a little different than being on the ground, right? Or being on top of the deck. There was a case out of Nevada that did not like it with those exact facts, by the way. But one of the things that the camera was doing was looking to the bathroom. I think the court was a little offended by that. But this wasn't like just purely a backyard case. This was also looking into windows. So you got to be careful that it just comes off as kind of offensive, right? But at the end of the day, my answer to you with those facts, if the neighbor could lawfully see the exact same thing and they can stand on their porch, which they can, right? We're not being ridiculous and we're not climbing ladders and stuff. Then using a camera to record what the neighbor could see is plain view.
Thank you.
You're welcome. Okay, so Okay, let me, Daniel, you're gonna be next. Let me answer one more question, okay? Because again, I got guys that are like begging for, they send me emails and they just want their answers too. So we have that one. And then also, my friend over here, Len, says 2913.16, improper handling of a firearm and motor vehicle. Okay, thank you, Len. That's the one that is more applicable. You're awesome. You're awesome, awesome, awesome. Okay, so we're done with that. All right, so let me answer one more. Let's see what this one is. Okay, this one is okay. This question is, they saw this video from armed attorneys, right? You guys know the armed, like this. It's a channel. Did you guys also? Did anybody make any comment about this beautiful pistol that's part of the blue to gold family? I mean, did anybody say anything about this? I mean, do you guys not care about guns anymore? Is that the sexiest thing you've ever seen? This is actually Rick's. This is a Flux Raider. It's built around a 320, a full size 320. It has you know, it has, look, I'm like a fool with this thing. It has 2 mags in here. You drop one, the other one drops automatically so you can reload. Has a red dot on here. This thing is hot shit. I'm probably gonna blow my computer screen away. But this is actually Rick's gun, his latest toy. Yeah, that's freaking, that's nice, man. Dave wants to trade his t-shirt for that. Okay. Okay, so let me answer the question. So an officer said, hey, look, there's a video out there about opening, it's 9mm. So opening a lock, a car safe. Like, can a cop, if a cop pulls you over, okay, and he asks you, hey, do you have a firearm in the vehicle? Something happened to the sound? All right, you there? Testing. On. You there now? Okay. Okay. Thanks, Rick. Okay. Okay. Well, actually, when I dropped the mag, it hit the mic and it pulled out the cord a little bit. So that's how smooth I am with the firearms. So the question is, if a cop stops you and the cop says, hey, do you have any firearms in the vehicle? And you say, yes, I have a handgun. And he says, where is it? And you say, it's in my locked safe in the center console, right? And the cop says, okay, give me the handgun, right? You know, I want to retrieve it. And the guy says, I'm not giving you my code. I'm not opening it, and so forth. What can the cop do? Okay. So the first question for you is this. Is the gun illegal in your state, right? Is it illegal to have the handgun in the car under those circumstances? If the answer is no, then you don't have probable cause, right? And there, if you don't have probable cause, you don't have the motor vehicle exception. Okay, the next question is this. Can you do a protective sweep of the motor vehicle, right? And seize it if you have reason to believe that the person is armed and dangerous? The answer is yes. The fact that the gun is in a locked container in and of itself is not going to, it's not going to necessarily restrict you from doing a protective sweep and seizing a firearm. But I got to tell you, if the gun is in a combination lock situation, what are you going to do? Crowbar it open? No, you're not. Okay. The first thing is this: do you even have evidence and circumstance that the guy is armed and dangerous? A lot of states do kind of hold that if the person has a firearm, you can kind of retrieve it and hold on to it during the duration of the traffic stop, almost as a matter of routine. What I teach at Blue to Gold is that, are you disarming your fellow brothers and sisters on a traffic stop? If you pull an off-duty cop over and he says, yeah, I got a gun, in my backpack, are you seizing that firearm? And the cop is like, no. And I'm like, why? Because I don't think he's a danger. So do you think that just because a person is not a police officer, but they're 10 and 2, yes, sir, no, ma'am, type of person, they have a license, they're on the up and up, but they just don't want you touching their gun, is that person now armed and dangerous? Right? Is that your opinion of people who carry concealed and exercise their Second Amendment rights? The point is that, let's be real here, okay? In 2024 and beyond, 2025 and beyond, just because a person has a firearm and that's all they have, right? Why are you considering them armed and dangerous if, and so forth? So if you don't, just because they have a gun in the locked compartment does not, to me, make them armed and dangerous. In fact, it maybe makes them the opposite of armed and dangerous, because you got a person telling you they have a firearm, they're being on the up and up, they're lawfully possessing it per your state, and also they have it in a locked container. Isn't that how lawful, like kind of like responsible people maybe hold firearms? So the final thing is this. I do have some cases where cops will open up a glove box, retrieve the firearm, and so forth, meaning, with a key. And the court upheld it because they found that the driver was armed and dangerous. But here, at the end of the day, if you don't have probable cause for a crime and you don't have specific facts that they're a danger to you, then why don't you just get them out of the car, put them in front of your buddy bumper, take care of your business, and release them with their citation or warning, and not harass them and try to break open their safe just because they're exercising a Second Amendment right. Okay? There we go. Okay, who's next? We got, that's my question there. Daniel, let me turn your mic on.
Hey, Anthony, can you hear me?
Loud and clear. What state are you in?
Rutland, Massachusetts.
Oh, nice.
So
the answer is whatever, I don't mean to cut you off, but whatever your question is, no, you cannot do it, but you can still ask.
Yeah, exactly. One of the most restrictive states.
Totally.
So an LPR question to you. So we just got them. We have them only on our cruisers.
Yep.
So obviously the recording of the information is mobile. We have
Yep.
none on poles. I'm wondering, nothing's jumping to mind, but I'm wondering what you think about that. Is there a difference when you're talking about mimicking GPS, whether or not the camera is mobile versus the camera being in a fixed location?
No, there's no difference. And here's the thing. The great thing about Massachusetts is you have the McCarthy case, right? Have you heard about that case before?
I had and kind of forgot about it, and then now.
Yeah. McCarthy is just, look, it's a wonderful case. And I got to tell you, like, I know Massachusetts is a restrictive state, but I really agree with what they did there. They really analyzed LPRs and they talk about the social implications, which I think is a valid concern, but they really got it right. They talked about the long term, at some point they become, at some point these LPRs can become problematic. But the way I read that case, the fact that the LPR is mobile, it's not going to make a difference. They still talked about, hey, how many LPR cameras do we have? And we're talking about like Las Vegas style LPRs and they talked about how long is the information being retained? Does it replicate GPS? Are they put in sensitive places? When you come to this LPRs on patrol cars, you're still checking all the right boxes, right? There's still not that many. Like, I mean, again, I think that every police car can have an LPR and still not have an issue in Massachusetts. But it's, how long you retain that information. You should purge after some, amount of time. You're not putting in an LPR equipped car in front of the mosque. You're not doing stuff like that. So I still don't think that under McCarthy, which again is your case to go to, you have any issues. I think you're good to go.
No, in terms of searching the information, we have Motorola, so they do
Yes.
a great job. If I was to look up your plate,
Yep.
for 6 months, it would show me everywhere that we saw you with a HD picture.
Yep.
In terms of searching that, what's my legal standard there? Is it just reasonable suspicion to look through it, or?
Well, I'm not aware. Well, look, under the Fourth Amendment, the answer is there is no requirement for any level of suspicion to run somebody through a government database, right? Because the person still cannot claim that there's any reasonable privacy. But I got to be careful about Massachusetts here. But I don't know off the top of my head any case that says you need reasonable suspicion. And I wouldn't be surprised if there was a case in Massachusetts, but I'm not aware of any case that says that you actually need reasonable suspicion to run a person through your databases. Are you aware of a case?
No, it's when I went through the training, the gentleman that did it was with the California Highway Patrol, and he had some interesting takes on it that I don't know if that was just California, about sharing the data with other agencies and the liability that creates, and what you actually need to search the database. Mass is a very weird state. Like even on our body cameras, like we sometimes need a warrant to search our own camera footage.
Well, you guys have a case about that involving that DV case where they looked back at it and they saw the
guns,
the curtains, So that's probably why. But even that case is actually mind blowing in a way. I'm not sure they got it right on that, but but that's Massachusetts for you. But the point is that what a lot of cops will tell me, oh, Anthony, the Georgia, the Georgia equivalent to NCIC, whatever, Georgia, I think it's Georgia CIC, or, in California, Nevada, we can't run this without, an actual investigative purpose. We have to have some investigation we're working. all those policies and so forth, quite frankly, yeah, GCIC, all those really are actually are agreements between your agency and who supplies that database. It's not it's not a constitutional issue. It's an agreement issue. Like even NCIC will say things like, you should have an investigative purpose to run people through NCIC. And we don't want to abuse it. We're not going to run our babysitter, even though we would love to. We can't run our babysitter through NCIC, right? However, I guess my point is that even if we had a person, so even if we had a person go through a parking lot and just start running every plate that they see in the parking lot, and boom, and then they run the RO, the register owner, and they find out that person has a warrant, right? And then they arrest that person. Is there any issue there? Constitutionally? No,
No.
zero.
No.
Could NCIC or whoever runs your database say, hey, look, you're kind of overwhelming our system here? The answer is yes. I'll give you an example. In Georgia, there were some officers who wanted to run everybody on a hotel registry, right? And they got the registry information lawfully. It was consent. They didn't demand it or anything like that. But they just want to run everybody. But then they looked at the GCIC agreement, and it says that you need an investigative purpose, right? It has to be, and you just randomly running people doesn't seem to be an investigative purpose. Right? You with me on this?
Yes, I am.
And I'm like, and they're like, hey, do you think what will happen? I said, nothing legally. If you find somebody with a warrant and you go serve it at the hotel and you find drugs on them, whatever, it's all good to go. The problem is that I guess potentially GCIC, Georgia, Criminal, Information Center, whatever, could call you up and say, why are you running hundreds of people a week in an agency with 4 people? Like, what are you guys doing over there? Like, what crime are you? And you tell them what you're doing. They could be like, look, that abuses our system. It's overloading our system. That's not what it's there for. It's not there to randomly run hotel guests. Knock it off, or we're going to cut you off. Could that happen? Yes, but it's two different. It's 2 different issues going on. So legally, yeah,
it's interesting because what you're saying. So our agreement must be. I never thought about it like that. So thank you, because our license plate readers are set up here in Massachusetts. They're running every single car plate that's coming by for the vehicle. We're not allowed to run the registered owner. We don't need to get into that, but it's running every plate. So my guys all the time are getting like revoked plates or stolen plates or whatever it is. But okay, well, thank you for your time, sir.
And I don't see a problem with that, by the way. And I guess it's only going to be a problem when the Massachusetts people, whatever who runs that database, say, it's overloading our system. The queue times are too. We have to do $1 million of investment, and then I'm just saying like. That's going to be the issue. It's not going to be any privacy interest. It's just going to be, overloading the system.
Thank you, Anthony.
When everybody's doing. You're welcome. Okay. Okay. Does anybody else have a question? Okay. If you do, please ask it, and I'm going to answer another question on my iPad here. So, okay. So, does anybody have a question? Let me see here. You're welcome. You're welcome, sir. Somebody says that the webinar is amazing. They're getting a lot of information out, but they had to run to and go take a call. Okay, so this question is kind of convoluted the way it's written, but I think I understand what they're talking about. So this cop sees a photo of a Snapchat, so it's probably like a screenshot, and the Snapchat shows it basically shows like a person having a firearm. So I want you to think about like an ex-girlfriend, right? An ex-girlfriend is, takes a photo, a Snapchat of her boyfriend, like he shows the gun to her. But then like a month, maybe she saves it because she wants, maybe something like this. One day he pisses her off and she wants ammunition against this guy. So a month later, he cheats on her, and she calls the cops. The cops come over and she says, hey, look at the phone. Here's a picture of his Snapchat, him holding a firearm and so forth. It's a month ago. He's a prohibited person, and we go from there. Does that give you probable cause to go get a warrant and so forth? What is your initial intuition answer with those facts alone? What are you kind of leaning towards? Yes or no? Yes. too long. Sounds a little stale. Okay. So I'm going to tell you that if I was your judge, okay, and I like, actually, Brian is probably has the most correct answer. If I was your judge and all you had was a picture of a guy holding a gun, 30 days ago, I would not give you a warrant. And here's why. Because I need the one thing we have a staleness issue. The one thing that I would like to know is, why do you believe that this firearm is actually his? Meaning, how do we, where's the proof that it's just not him holding a friend's gun a month ago and just kind of showing off, right? So that's the missing ingredient for me. Why do you think that this is not just a one-off, right? Well, how do you know it's real? I'm actually, by the way, I got to tell you, Brooks, that's usually not an issue. If it looks like a real gun, and the officer's like, based on my training experience, it looks like a real firearm. Could it be an airsoft gun? Absolutely. But all you need is probable cause that it's a real gun. When people are holding up guns in pictures, normally they're showing off a real gun, right? There's not a lot of street cred in showing off an airsoft gun. I'm not saying they can't do it, but it's not usual. Does that make sense? Okay. So I think what I want to hear, well, if they're on, Brian says report to the parole officer. If they are on parole or probation, that's totally different. Change the facts, change the answer. But if all you have is a single isolated picture, you don't have a history of gun crimes, you don't have any other evidence. Was the picture even taken out their house? Can you see the curtains that match? You know, the point is, I want more investigation. Just one single picture by a mad, angry ex-girlfriend. You guys with me on this? I think you can do a little bit more footwork and then get a more solid warrant. Does anybody have a question? Somebody did have a question that weren't able to answer it on mic, but let me ask you. I do have you can call in as well. Okay, but look, Gabriel says, in regard to utilizing a drone for a search warrant, does the search warrant need to articulate the use of the drone in thermal imaging if officers plan to turn it on during the execution of a search warrant? If the use of the drone is not articulated in a search warrant, could that hinder any evidence drone captures? Yeah, absolutely. I mean, look, there is a case out of Indiana where during a, Jeff, do you have a question? Or was that just a yes? So there's a case out of Indiana where the officers during a SWAT standoff used, just used a drone to see in the windows and so forth. And the court held that was a search on the Fourth Amendment, and it actually, you needed exigency, which I forget. I think they had a problem in that case. There was no exigency and so forth. Even though I said it was a SWAT standoff, but there was the standoff was problematic. Okay, you're welcome. But look, to answer the question, the scope of the drone use should be in the search warrant. Why wouldn't it be? It's just a few extra lines. We desire to deploy a drone for to look inside the home, thermal imaging, and so forth. The drone should, or the search warrant should, describe the scope of the search. Does that make sense? Okay. We've got the snaps. I think that was his question. He had the drone question. All right. Okay, so the next question is, oh, this one already answered that one. Okay, let's see this one. Okay, this is a common question. So I think that this is a question from an officer in Nevada, but the question is, if you remove a subject from a vehicle and you find contraband on his person, do you now have probable cause to search his vehicle if he is no longer in it? Well, I've talked about this issue many, many times on my YouTube channel, and the answer is not necessarily. You know, you need a nexus for why do you believe that there's evidence in the vehicle. So the best way to look at these, can I search the car cases, is what would you tell the judge, right? I mean, if you go to court, I'm sorry, to the judge, and you're like, Your Honor, I did a pat down on a subject and I found a methamphetamine pipe in his pocket. And the judge says, okay, you want to search the vehicle? Yes, Your Honor. Why? Just because drug users often have drugs in their car, maybe that will work. What about the fact that it is his car? What about the fact that he says he's a 2 gram a day kind of guy? What about the fact that he tried to run from the car? I guess the point is you should have something more than just finding something on someone, but it's not hard. It's just articulation. Is that you guys with me on this? It's just articulation. Why do you think that there's more evidence in the car? That's all. And you just need probable cause. And I don't want cops going to court and saying, "Well, Your Honor, PC for them means PC for the car." No, that's not the law. Okay, that one's pretty much done. All right, we got that one done. All right, what's the next one? Oh, somebody said, so I did a video, or I did a show. I was talking about search incident to arrest. So somebody on the chat said, just do a search incident to arrest, and the vehicle's being towed. That's fine. It would be inventory, right? You're not going to do a search incident to arrest of a motor vehicle when they're in handcuffs and they're away from the vehicle. But if the car is going to be towed and the tow is legit and it's on the up and up, then you would get an inventory and you can probably find the evidence that way. But the tow does have to be legit, by the way. Okay. So I talked about, this issue about arresting people on the curtilage, right? And I said, like, if you go to somebody's house and you have probable cause, let's say that they just committed a domestic at their girlfriend's house. They don't live together, and he's at his house and he's on his porch, sitting on his chair, and you walk up there and you just say, "Get up, you're under arrest." Is that problematic? And the answer is yes, right? The answer, why is it problematic, is because when the person is on their curtilage, which we talked about during this webinar, when the person is on their curtilage, you got to be very careful about going onto their curtilage with the sole purpose to make a warrantless arrest, because the U.S. Supreme Court said in a case called Payton that you cannot enter a person's home in order to make a routine warrantless arrest unless you have exigency or an arrest warrant. Well, then in a case called Hardinus, Florida versus Hardinus, the Supreme Court also said that we treat curtilage the same as the home. Therefore, since you can't go into the house and make a warrantless arrest, what gives you the authority to enter the curtilage and make that warrantless arrest? It is problematic. But I said, look, if you had exigency, their consent, and or arrest warrant, you can do it. And the person rightfully said, he was like concerned, like he said consent. He said there's never consent to an arrest. That's not true. That is absolutely not true. It's rare, but there can definitely be consent. So let me give you an example. You call up the guy and you say, "Hey, it's rare, but listen to me." You say, "Hey, your girl is saying that you slapped her in the face because of XYZ." And he says, "Yeah, I lost my temper. I shouldn't have done that." Okay. So you did it, right? Okay. Well, look, that's we have to make we have to make an arrest. And where are you right now? He says, "Well, I'm at my house, right? Sitting on my porch." And you're thinking about what Anthony just told you, right? You should not just go to his house and just hook him up as a routine arrest. And you say, "Well, look, here's the problem. I'm not going to just go to your house and just arrest you because, I don't think that's the right thing to do. I either A, can come there and we just resolve this tonight, book you in, you can bail out, you can be out by the morning, or we can get an arrest warrant and we can come back and, potentially, come into your house, or arrest you at your job and so forth. We have to make this arrest. We do have PC." And he says, "Oh, well, do you think I'll be out by 8 a.m. because I got to be at work?" And the cop is like, "Yeah, you're going to probably be out by tonight." And he says, "Okay, well, come over to my house and arrest me." I'll take the ride tonight and I'll just answer for my charges and get booked in tonight. I don't want you coming to my house. I'm sorry, my house or my work and taking me in custody and embarrass me in front of my coworkers. Can he give you consent to do that? The answer is yes. I know it's a minor issue, and I say things sometimes when I don't explain it, but I want you to know that even though it is rare, I'm glad this officer kind of said that you can't consent to an arrest, but it actually does, it can occur, even though it is rare. Okay. Let's see what this question is. Oh, this is actually a good one. And then let's see what Brian says. Brian says, "What if you go to the front door and knock and they answer and you snatch them when they open the door?" No, 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 no. That's body snatching, and there's a movie from the 1970s on it. And you shouldn't do it then either. So the point is, you should not be snatching people from their home. The Supreme Court in a case called Kylo said the unlawful entry into a home by even an inch is too much. What gives you the authority to pull people out of their home? That's not hot pursuit. You need exigency for that. You may not have exigency. You don't have an arrest warrant. You don't have their consent, and so forth. Now, Brian says, what if they step out when you ring the doorbell? Okay, that is a debatable question. In the Ninth Circuit, at the Ninth Circuit, the question is this, okay? I'm going to tell you what the Ninth Circuit and some other courts have said. When you entered their curtilage, what was your primary intent? When you entered their curtilage, what was their primary intent? Was your primary intent to get him out of the home and snatch him up? If it is, then I think you have a problem, right? I think you have a problem. Daniel, will you come on the camera microphone and answer that question? Ask that question. What is your primary intent? What I teach my cops is this: why don't you just talk to him? Why don't you have a real knock and talk and ask him what his side of the story is, and then, if you still have probable cause, arrest them. Does that make sense? That's what I teach. Have a real knock and talk to him. If you still have probable cause, arrest him. But don't go there and just solely snatch him up immediately. Okay? Daniel, do you want to come on the microphone? Let me answer the question, and then let me answer. Okay, Daniel, let me answer this question, and then I'll answer yours, okay? So, can a conversation between an arrested individual and medical personnel be used as probable cause? A person is arrested and for suspected DUI after a vehicle crash. They are taken to the hospital for medical clearance before being accepted into jail. During the hospital evaluation, the doctor asks the arrested individual if they use drugs. The patient admits to drug use and discloses the type of illicit drugs they ingested. This is going to contribute to the DUI. Can this overheard conversation be used in a probable cause statement to request a warrant for a blood draw as part of the DUI investigation? Does it fall within the plain hearing concept because the officer is permitted to be in the hospital room with the arrested person for safety reasons and so forth? Are we good? Yes or no? What's your answer? Yes or no? And the answer is going to be yes. Okay? The answer is yes. Why? Because this is not interrogation. Number one, this is not a HIPAA violation. So don't start with the HIPAA stuff because I know a lot of cops are, well, it's HIPAA. No, HIPAA has an exception for law enforcement. Law enforcement are allowed to be in the room. And the second thing is, this is not interrogation. The officer is not the one asking the questions. Is the officer lawfully present? Yes. Under HIPAA, being present during the medical screening is allowed because of safety issues, like the officer said. The second thing is, the officer is not asking any questions. He did not tell now he would have been like, "Hey, doctor, do me a favor. Ask him if he ingested any drugs." And the doctor asked that question on behalf of the police. That would be a Miranda violation, right? Because you're conducting a functional equivalent interrogation. But here, it's not even a violation, not even a Miranda issue. So we are good to go. Use those statements in the PC statement. What's up, Daniel?
How's it going?
Good, man. What state are you in?
In Nebraska.
Okay, sorry.
Yeah. So we just passed some medical marijuana laws in November. Obviously, they don't have any regulations or how anything is going to work yet. It's still all up in the air. So my question is, now if I do a vehicle stop, I go up, I smell marijuana, then you have PC to search the car and everybody in it. once these medical marijuana laws are in effect and people are legally allowed to have, whatever the amount is on them, how does this affect an officer's PC to search a car?
Good. It's a great question. And so again, we don't have recreational use. We just have medical, right?
Right.
Okay. So the way that other states have handled this, and a lot of states have gone through these growing pains with marijuana, is just the first establish whether or not they actually have a medical marijuana, because you have to have identification for the card, right? Medical marijuana card.
Right.
Yeah. So that's the question. And if they don't, if you smell the marijuana, then also I haven't seen the Nebraska law how it's written. Can they actually? And maybe you can tell me. I'd like to know because I do teach a lot in Nebraska. Can they actually possess like a sandwich baggie of marijuana in their purse, or it has to be? Go ahead. Do you know?
Yeah, I believe it's actually a fairly significant amount,
Mhm.
like 5 grams or something like that of marijuana, which is
5 grams is not that. Yeah. Well, I mean, shit. It ain't New Jersey 6 ounces.
well, and it might actually be 5 ounces,
It might be
not
5
5 grams.
ounces. Five
Yeah.
grams is probably too small. It might be 5 ounces. But so look, the first thing is you have to know your transport laws, right? Because that's going to make a big difference. Like, so for example, in California, you can have it in it says that California law says that it just has to be in a sealed container. Well, courts have interpreted sealed to also mean a loose sandwich baggie, even without the zipper, the whatever you call
wow.
that thing.
Yeah.
And so and so that's the first thing. Okay. But the second thing is they they do have a burden of proof here. So if you pull them over and you're like, hey, I smell marijuana. Do you have a medical marijuana card? And they say no, well, you have game on, right? That's
Right.
recreational use. But even if they say yes, and they do not prove to you, they don't give you any evidence that they do have a medical marijuana card, and you don't have a way to look it up, then I think you have at least probable cause of recreational use. It's like having a driver's license. If they don't want to prove that they can drive, then you can assume that they're driving illegally. So I guess the point is that if they don't have the medical marijuana proof, then you do things like you've been normally doing.
Okay. Sounds good.
Let me see what David says though. Oh, I'm sorry. David's in North Dakota. Transport must be transport. Yeah. Look, and David's bringing up transport laws. I can tell you that transport laws is a very big deal. You have to know how your law is written. Like, so for example, California is kind of hard, but in Illinois, it has to be in an odor-proof container for recreational use. This is not, they don't, medical, whatever, but for recreational use. So if you can smell raw marijuana emanating from a vehicle in Illinois, even though you can have up to whatever 2 ounces, whatever it is, you can still search the car because it's proof that they're violating the container law. So container laws are also important. But
Okay.
can I tell you one more thing, Daniel, just to tell your
Yep.
friends? The one thing that I have found in my years of experience is that when states first initially start legalizing marijuana, a lot of officers want to do what's called compliance checks. And they'll like, well, yeah, you're legally carrying, yeah, you can have recreational use or you can have medical marijuana, but I want to just make sure you don't have over the certain amount, or I want to make sure it's in the proper container. Negative. A lot of cops, they want to do that because they just want to make sure they're complying with the law. But the answer is you have to have probable cause, not just a hunch or just to want to make certain that people are not violating the law.
So I guess if you smell marijuana, they have proof that they have a card that says I'm allowed to have it. You don't have any legal right to verify the amount that they have on them.
Absolutely not. That's the
Okay.
same thing as seeing a pill bottle in in a person's vehicle. Let's say it's narcotics, right? And they're not
Mhm.
DUI, and you're like, hey, I want to search that pill bottle, make sure you're not abusing it, or whatever. You're like you can't, or I want to search your alcohol to make sure your cigarettes, make sure you pay the taxes, to make sure that these are not black market cigarettes. It's the same concept. You don't have
Right.
the government doesn't have a right to just prove that people are not criminals.
Gotcha.
You have to have PC. If you don't have PC, you're not searching.
Okay.
Yep. Cool.
Thank
Okay,
you.
buddy. You're welcome. Okay. Hey, so Carl, can I just try, Carl? Let me just try to turn the mic on. If it doesn't work, it doesn't work. But it's a lot more. It's better for everybody if you actually can talk because people enjoy it. It makes it actually a lot more interactive versus me just reading what you said.
Yeah, I had a button come up says, "Do you want to unmute?"
There it is.
Where were you before?
Well, yeah, it's cool because I can't turn your mic on without your permission, and vice versa. You can't turn on your mic without my permission. So what? I didn't really read your question at all Yeah. So what state are you in?
I'm in Georgia.
Okay, cool.
And before I start, I bought your book. Awesome book. It stays on my desk like a Bible.
Amen, brother.
You were down here for a Chiefs conference, and I purchased one then.
Nice.
But my question has to do with my environment, and it may not be something that anybody else deals with often, but I operate several state campuses for vocational rehabilitation. So to understand the student body, which are residential, are adult age, and they are special needs.
Special needs.
Now,
Okay.
a lot of our instructors come from a public school environment, and I've come across situations where I find out afterwards, or I've walked up on them in the process, doing what I consider to be a search of a student. They've asked them to empty their pockets, and then they're rifling through their backpack. And when I've talked to the administrators about it, they say, well, we do ask them to empty their pockets, so that's consent. And my argument about that is, well, they're under duress. You've got them pulled into an office, and I don't really feel like that there's really a freedom of choice there. Just on my side, that's what I'm thinking.
Sure.
And then, of course, the idea that they're checking these students for safety purposes. And I'm like, well, wait a minute here. We have a 1985 decision that says that students have rights to privacy as well.
Yeah, TLO.
And, yeah, exactly. And we also have a situation here where you're kind of doing this on a basis that isn't really set. You're saying safety is a general statement. And if that was all I had to do as a police officer, I could just say safety all day long.
Yeah.
And it's not prescribed enough. So I don't feel like that these searches are done in a good fashion. And they're kind of poo-pooey about it with me.
Yeah.
Because they're every time we have a school shooting, this is an argument that I have. And
Yeah.
I feel like I'm right. But at the same time, I wonder if maybe there's some places here where I'm wrong.
Let's walk through it a tad to make sure I got the full context here so I can give you some more advice. Number one is describe again. I want to make sure I got the environment right. These are adults or children?
They are adults, age 18 and over.
Mhm.
They may not be fully emancipated due to their special needs.
Yep.
They may have guardians.
Okay. So, but they're all, but are they also like, not only do they have special needs there, autism and so forth, but do you also have like troublemakers there too? Like people who are disciplinary issue kids?
Well, here's the other thing. They don't do a criminal background check on enrollment. So they don't know fully what they're getting. They're
But why?
making some
But they're sent to your, they're sent to your school because of their learning
Correct.
disability. But
right. And then we find out some of them do have a criminal background and they're acting out while they're on the campus.
Okay, but they're resident. This is also residential.
Correct.
Okay. So look, this is going to be an interesting one. I think the law is in favor. Okay. The next thing is, did a search even occur? Okay. So a consent, right? They said, hey, look, we're asking these people to empty their pockets. Is that consent? Well, consent requires three things. Number one, it has to be voluntary. That's going to be the issue here. Number two, the person has the authority to consent. You can consent to search your own body and the scope of the search, right? A pat down is different than a search. Okay. So the question for us is, when you ask this person who is obviously in a setting because they have a learning disability, a mental disability, and so forth, low IQ, whatever it is that going to be a factor in whether or not this is lawful consent? Absolutely, it is. Of course it is. Of course it is.
Oh, we're case by case here. Trust me.
It is case by case. I mean, clearly some kids may not be we can agree that based on what you see in their intellectual abilities that they can't consent. They just don't have the capacity to consent, and others are gonna be like, oh yeah, they're high functioning, right? So
yes.
So look, that is a question, a fact specific question. There are absolutely cases out there where people with IQs in the 60s and 70s have lawfully consented. They murder people, whatever, and the court has upheld that they consented to a search of their house or their room, whatever. So I can't answer that without knowing exactly what is, but I can tell you that that whether or not that was consent is going to be a factual issue for the court. But let's presume, because that's the harder case, is presume that it's not consent. We tell the person, hey, you got to empty out your pockets. I got to tell you that the case law on this issue is in favor of allowing this. And here's why. Because this is not a regular, first of all, you can't do this in a regular school environment. I mean,
No,
I don't know if they think they're doing that in
they are.
In Fulton County. Yeah, they probably are, right? In Fulton County and shit like that. But look,
Yeah.
I can tell you right now that, because you are correct that they do have expectation of privacy. If I'm a principal and I tell a kid to come into my office and I say, hey, empty out your pockets. And the student says, why are you asking me to do that? And I say, because I'm telling you to. I don't need a reason. Yes, you do. You need at least reasonable suspicion to conduct a search in a school environment, right?
Right.
Okay. But there's case law, mostly out of the Fifth Circuit, which is Texas, which is going to be very politically the same, probably as the 11th Circuit,
Yeah.
which is what you're
Yeah.
in. But there are cases out there where a lot of these cases come from not residents, which actually helps my argument, but they come from what do you call it, like alternative schools, right? Behavioral schools.
Yeah.
And I know this is a little different, but the point is that as long they allow these school administrators to do suspicionless searches, as long as there's some rules in place. Number one is that it's not discriminatory, meaning it's not just the kids from a certain race or dressed a certain way. You got to be careful with that. Not just the boys get searched, but not the girls, right? It has to be, it has to be like, if you're saying that everybody has to empty out their pockets, well, that is everybody's treated the same, just like TSA treats all passengers the same. The second thing is there has to be a compelling need. Is there a reason for the school to do this? Well, look, you are in first of all, a residential facility, which means that you are their guardian in at least some sense. They are part of your charge. The behavior schools are a little easier because they're by definition problems. They want to cause problems. But, I would ask you, like, why is the school doing this? Do you actually have a reason? Like, why they just want to, what are they looking for? Drugs, knives?
Generally, what happens, what I've come to see as a pattern is something will happen that is not fully related to anything they would have on their person. So, for example, they will be dealing with a student and first off, just to kind of set the setting a little bit here.
Yep.
What you have to picture is maybe sometimes like a 30 or 40-year-old with a 14-year-old mental capacity.
Mm-hmm.
So you're looking at a fully grown adult that is acting by your first your
impression,
impression is acting really strange because they're not acting like an adult, they're acting like a 14-year-old.
Mm-hmm.
So their tone, what they say to you, how they say it, how their behavior is completely wrong for somebody that age.
Right.
So you got that part in there, and I've seen where instructors have dealt with somebody like that, and it frightens them to put a word on it, and of course they want to make sure they're safe while they're dealing with this person. So I've seen them do that for their own personal safety, and I've also seen them do it where, for example, somebody had said something like, "So and so's dealing drugs." Another student would say something to that effect, or so and so is using drugs. So they'll bring them in. They say, empty your pockets. Let me see your backpack. They'll go through their backpack looking for the drugs.
Yep.
Or because the person got into a harsh verbal altercation, maybe they were being aggressive, and somebody says, yeah, he probably got a knife. That's enough for them to want to go ahead and search for weapons.
Well, we know, but you would agree with that, wouldn't you?
I'm sorry?
You would agree that if somebody says, hey, this guy has a knife, that would be enough.
It would be enough for me to go looking for a weapon. True enough.
Yeah.
My question is that when they're doing this as a civilian, not as government. Is there a different standard that's applying here?
Yes, it's an easier standard. So we know from TLO that the standard for civilian school administrators, look, TLO is not dealing with adults, but I guess you can still make some leaps here that there's some similarities, but because they're under your charge. But TLO says that civilians, all they need, if they're enforcing school rules or the rules, or even making sure crimes aren't occurring in the school, all they need is reasonable suspicion. And remember TLO, Tammy Lee Owens, she was accused of selling drugs, marijuana in the school. So it's a very similar case. And the principal went up there and searched her purse and found marijuana and P&O sheets and a pack of smokes. And
Right.
right. And the Supreme Court upheld it because they don't work under the same rules as law enforcement. But
Right.
remember too that law enforcement can become the agent of the school. I have a class on SROs. When can the police search a person with reasonable suspicion in a school environment? And there's an analysis, and if they really are doing it on behalf of the school, then it should be fine. And they're not looking to they're not doing it like an independent criminal investigation necessarily. But
Right.
the point is, look, if we go to court on this, and and we hear like the environment and that these are kids under the guidance and the control of the states. They have mental issues. They, drugs have been found in a school. We do have a problem here of these issues. They're mentally disturbed or, whatever. I mean, I don't know what disturbed, but they have mental illnesses or disabilities and so forth. The courts are going to be very sympathetic to that argument, and they're going to want to allow the school to be safe because we don't want anybody to get hurt. So there is going to, the law is going to be in your favor to either ask or tell a student to empty their pockets, especially if there's reason to believe that there's drugs or some kind of contraband on their person.
Okay, so they're not violating their constitutional rights as adults.
No, not necessarily. I mean,
And
again,
not necessarily. I know it's case by case basis,
Yeah.
and different facts will change the answer,
Yep.
and
Yep.
I get that. So, and being case by case, literally, these are judged almost individually,
Sure.
and some are a little bit stronger. Some things seem a little bit less. I brought my some of the issues to my DA and discussed them with him, and he is very black and white about the Fourth Amendment in this regard. He doesn't feel like that those are necessarily reasonable searches under it's his interpretation.
Sure. No,
And
absolutely.
I'm
Absolutely.
like, going, okay, well, if any of this actually goes forward into a criminal case, then we would have to evaluate that. The reason why I'm asking is I want to make sure I'm advising my staff correctly, because there are some that have a concern. Am I allowed to search? And well, it depends on, and there's a whole lot of well, it depends coming out of me.
Mhm.
And when I'm saying a whole lot of well depends, I either think I'm getting something wrong, or I may be right to be cautious. So when I'm looking at what they're doing, I'm waiting for the day when some student says, no, you may not search me. And the teacher thinks they have a right, and then they try to enforce that. And then what am I dealing with?
Yeah. Well, I'll tell you here. I think here's the we can end it at this or whatever. At least some good guidance. I think that if you have, if civilians are treated differently, you brought up TLO. The second thing is if the school has specific facts to believe that there's contraband on the campus and that this person's involved in it, that's the easiest case. I would search them under the TLO type of special needs, to keep the school safe. However, I also would agree, and maybe the DA's with this too, that if you have a person and there's no reason to believe that they're involved in anything, we just want to do a search just because of them, or there's no randomity to it. It's just, what I want to, before I teach you math, whatever, I want you to empty your pockets. Right? The guy's an adult, and they have functional disabilities, but I want you to empty out your pockets. And we tap on the shoulder and say, "Hey, teacher, why are you telling this adult, to empty out their pockets just because I don't feel safe?" I do have a problem. I have a problem with that.
Okay, all right. So we're reasonable there. We've got a middle ground depending on
You should have a reason. You should have a reason why you're compelling somebody to empty out their pockets when they are an adult. And, even though the state's their caretaker, there should be a reason. However, even that's debatable. Depends on how that court looks at that facility. If it looks more like a prison, I'm not trying to be derogatory here, but
No,
more
I get what you're saying.
like a prison or,
more like part of the university system.
well, then I think that the probably not more like a prison, more like an apartment.
Correct.
Yeah, exactly. And then the rules
They're
apply.
free to come and go. They're not restricted in their movements.
Oh, they are? Oh, they're right. They're free to come and go?
Yeah, free to come and go. They have reasonable expectation of privacy in their dorm.
Oh,
They have common areas. They have public areas.
absolutely. I'm
Some
sorry, I
of
didn't
them
know that.
drive.
I thought it
Some
was
are very high functioning. Some of them are lower functioning.
Yeah,
The
I
ones
thought
that
it
are
was,
higher functioning, you may not even be able to tell the difference between like yourself and them.
Yep.
There are some where it's very obvious what their issues may be.
Yep.
And they're limited, of course, but
no,
that's
no, that totally changed. I thought I was thinking of of an institution where they're not free to leave.
No,
Now,
no.
that
This
is
is
you know,
very
that's
free, open campus
it's an open
settings.
campus. No, you absolutely that changes the rules. You got to be careful here. So you should
Okay.
at least have a reason for why you want them to empty out their pockets, not just because I don't feel safe because they mumble a lot or they have
Right.
scary eyes. You know what I mean?
Well, that would be discriminatory.
It
But,
would be. It would be.
So what I'm basically doing with them is I'm trying to apply a police standard in the public to them, and I don't know for sure if I'm doing that correctly.
I think it's debatable because you do have some special circumstances going on there. You know what I mean?
Yes.
Like, they are anyway. We do have to be careful, but at least if they have a reason, they heard there's a knife around, or somebody's bringing in drugs, that is different. I mean, the state has
we do go
obligation.
with it because we do have to default to safety because we have a small controlled community.
Correct.
We do have 24-hour living. So that small controlled community kind of offsets what we would do normally off campus.
Yep.
So when I'm talking to my officers, I'm like, well, be there. Let's do the search, get consent if all possible. If it goes south for whatever reason, we'll stop, reevaluate, see if we need to go get a warrant.
One final question for you.
Yes.
Are you going to be at the next Georgia Chiefs conference?
The spring conference?
Yeah.
Yep.
Okay, I should be there. I think
I'm good.
So come up and say hi.
Hey, I'm going to make you sign my book.
Hey, absolutely. I'll make it. Then that way you can't resell it.
Yeah, well, I'm not going to resell it. I've had a couple people try to steal it.
Exactly.
I've got a gun.
I love it. Not like
Thanks,
this
sir.
gun though. You have like this gun. That's a badass little gun. Do you agree, Carl? That's a badass little gun right there.
Yeah, that's really cool. It looks suspicious hanging off my shoulder all day, like I'm paranoid or something.
All right, good man. I'll see you at the spring conference.
Thanks, sir. We'll see you then.
You're welcome, my friend. All right, guys. I appreciate you. I think we really got a lot of case law out there. Thank you. You guys are just fantastic. I'll see you guys next week. If you have any questions for us, please go to our social media channels. Go to our bluetogold.com. Please, please, please. If Teresa is still here, yes, she is. Please, if you like what we're doing here, please follow us on social media. And with that, my friends, stay safe.